Hey everyone, my name is Eddie and I'd like to welcome you to this review of question number 2 of the California bar exam that was administered in July of 2016. And before we go on, I'd like you guys to notice something. I want you guys to notice the minor cut that I have on my forehead, and just don't get distracted by it. And I do want to say this, that notice how visible it is. And it's kind of relevant to this question here, to part of the question, because the question deals with notice, and of course you could throw in visibility there, and we are going to do that. There is a full text of this question below in the description, so let's get to it. Let's go to question number 1, and it says, what is the likely outcome of Ben's action? And what is Ben trying to do here? Ben, what are you trying to do here? It says Ben has commenced an action against Polly seeking declaratory relief that the farm is burdened by his easement. So I think Polly was just yip-yapping, and then Polly's just like, hey, I had enough of this. And he's like, Polly, let's just go to court and just finalize this. And that's what happened. So I'm sure you guys talked very briefly about what an easement is and how it's created. And here it seems like you had an express grant, and you could also argue that it could be created through estoppel. And then let me just go to the first lines here, because there's a lot of important facts here. It says, Al deeded an easement for a road along the north side of his farm to his neighbor Ben. So I'm going to say that that easement is going to go to Ben's home, but I'm also going to take it a step further here. I'm going to say that that easement is going to go all the way to Ben's front step. And I think Ben wants to say, hey, he wants to let everybody know that he has an interest in that easement. And then it says, Ben immediately graded and paved the road on the easement. So look what he's doing. He's moving fast. And let's see what he did. So a paved road can look like that. Now, for the purposes of visibility, I'm going to say that this image comes to mind, the yellow brick road. And Ben just wants to let everybody, the whole world, know that he has interest in that easement. Now let's talk about how easements are terminated. And now there is a presumption that easements are perpetual in duration. And I'm sure that you guys know of many ways in which an easement can terminate. And there is a very popular mnemonic, and it's called end cramp. And look at all these terms. But this is not the only way, and you guys know this. This is not the only way in which an easement can be defeated. An easement can also be defeated by a bona fide purchaser, or a BFP for short. And this concept here of easements is highly tested on the California bar exam. So I'm gonna take a side step here, and you guys already know this, but we're just gonna review this. So I just want to explain the dynamics between an easement, a BFP, and notice. So we're gonna use freaking Pikachu here, okay? And we're gonna say that Pikachu has an easement, and let's say he forgot to record his easement. Okay, so then we have a subsequent purchaser of the Servian estate, and let's say it's Mickey Mouse, and Mickey Mouse does not want any encumbrances. So Mickey Mouse can defeat the easement if Mickey Mouse is a BFP. To be a BFP, the person must pay valuable consideration, and also the person must not have notice of the other person's interest. If Mickey Mouse has notice of Pikachu's easement, and then Mickey Mouse will not be a BFP. So now let's go through these documents here, these instruments, and then we'll see if there is a BFP. We're on the search for BFP. That's what we're doing here, okay? Let's see. 2009, Al deeded the farm to his daughter Carol. There's no mention there of a purchase price. It could be a gift. Carol is not a BFP. Let's go on. In 2012, okay, and there we have a land sales contract. And what do we know about that? It did establish the sale price of the land. And also it probably established a closing date. And we know that Carol has to deliver marketable title by that closing date. And they don't want any encumbrances. And an easement is an encumbrance. And we also know that Polly probably has notice of the easement. And also I want to say this about contracts. Contracts do not convey interest in land. So the any terms there will not run with the land, and there is no BFP. In order to convey land, the person must use a deed. Okay, so that easement by Ben is not terminated by that contract. Now, let's go on to 2014. And there we do have a warranty deed. So if we have a BFP, and then that easement can be in danger. Okay, so let's see. Now we have to determine if Polly is a BFP. Now it says that she paid valuable consideration, so that element is met. Polly paid Carol $100,000. Now, did Polly have notice of that easement? And it says here that in 2011, Ben recorded his deed to the easement. So in 2011, Ben put the world on notice. He said, hey, world, I have interest in this easement. Okay. And you could also make the argument that Polly has inquiry notice because Polly observed Ben on that easement. And visibility, again, that word, visibility is sufficient to put a prospective purchaser on inquiry notice. So Polly is not a BFP, and Ben's easement is not terminated by that 2014 deed. So it seems as if Ben will prevail. So, okay, fantastic. Let's go on to question number 2. Okay, now let's do question number 2. And question number 2 has 2 parts. It has the breach of contract question, which we are going to deal with now. So let's see what Polly is trying to do now. Polly, what are you trying to do here? So she's attempting to enforce the executed contract of 2012 that contained a covenant against encumbrances with no exceptions. So Polly here does not want any easement. None. So let's talk about that 2012 contract between Carol and Polly. And again, the contract did not convey any interest in the farm. So that takes us to the 2014 warranty deed, because we want to get the whole picture here. And of course, you already know that a warranty deed does convey interest in real property. And a proper conveyance requires certain things. It requires formalities, it requires delivery, and it requires acceptance. So I have a feeling that Polly will have to make a choice here. As for acceptance, a buyer can't accept or reject the deed. So Polly can reject that. If the buyer rejects, then he can bring a suit to enforce the terms of the land sale contract. And let's see what Polly does. Here, Polly chose to accept the deed since she paid valuable consideration. How much did she pay? She paid $100,000 upon delivery of the deed. And then it says that she even recorded the deed. So now let's talk about the results of those actions. And let's talk about the merger doctrine. If a land sale contract is present, which it is in this case, it will merge into the deed. And once the deed is conveyed, the terms of the deed will supersede the terms of the contract. Again, it will supersede the terms of the contract. So it's not really a merger in that sense. In other words, the terms of the contract become null. Here, the 2012 contract merged with the 2014 warranty deed at the time of closing. As such, only the terms of the deed are valid, so a court is only going to consider the deed. Polly brought her claim against Carol either in 2015 or 2016, but it was done after that warranty deed was recorded. Since the terms of the contract merged into the deed in 2014, Polly will not succeed in the claim for breach of contract. However, note that Polly may have a valid claim based on the warranty deed. And that discussion now follows. Okay, you guys, last question here. We're almost done. I want you to get pumped. So here we go. We're still on question number 2, part B. And it says, what is the likely outcome of Polly's claim of breach of the covenant under the warranty deed? So let's talk about warranty deeds. And these are instruments that make several guarantees that must be in effect at the time of the conveyance. And one of these is a promise that there are no encumbrances aside from those that have already been disclosed. So if there's an encumbrance, then here Carol would have a duty to disclose it. As was stated earlier, an easement is the type of encumbrance. So let's discuss Ben's interest here. And here the issue is whether Carol disclosed the easement. As discussed earlier in question 1, Ben did in fact have a valid easement. And we know that that disclosure was not made at the time of conveyance. And there was even a dispute as Polly blocked Ben's use of the road after the conveyance was made. So here Carol will probably be liable. Now let's shift over to water company's interest. And here the issue is whether Carol disclosed water company's easement. And the water company easement deed was made in 2013, and it was even recorded. The 2014 deed discloses the encumbrance. And as stated earlier, Polly accepted the terms of the deed, including water company's easement. I mean, it was expressly stated there. And as such, Polly will not prevail due to Carol's disclosure. So Carol, awesome job. And that's it. Question 2 is done. So best wishes to everyone when those results are released. Thank you for watching. Until soon.